This could very well be the most egregious overstepping of the government since March 2020. Welcome back to the channel. Today, it's kind of going to be a weird reaction video. I normally don't do reaction videos, but this was so important and so new and so changing. This is going to be a very dynamic issue that I thought it was important to strike now. I believe I've already been shadow banned by LinkedIn on this issue. If you don't know what shadow banning is, it is when a social media platform edits and controls who can see what content because they disagree with what you have to say. And so being somebody that deals in business matters and has a MBA degree, I think it's interesting that a business social media platform like LinkedIn may be shadow banning me on an issue that will greatly impact commerce in America. Before we get started, I need to state a few things. First and foremost, I am not a lawyer. I have no legal training to give any type of legal opinion or advice. If you have any questions that are legal about how this may impact you, your business, your career, etc., you need to seek professional counseling with a bar certified lawyer in your state. With that said, I do have a MBA degree, and I am speaking as somebody that consults small businesses. So everything that you hear is based off of my professional education and training. And I also have experience with working in politics and working in the government. I worked for 20 years in the court system. Again, I'm not a lawyer, but I did work in the court system. I also served in elected capacity as an elected official, and I worked with various elected officials, including the governor of Florida, among others. So that my opinions expressed are my own, and it comes from my political and my business background. So please, I ask you to investigate this on your own and to understand what's going on and do your own research. With that said, today is January 6th, 2023. And already 2023 is starting off with a bang, because yesterday, January 5th, the Federal Trade Commission announced that they're going to be proposing rule changes that may abolish non-compete clauses in America. Now, if you don't know what a non-compete clause is, the layman's definition of it basically is when you enter into an employment contract, or you enter into any type of contract that involves business, there may be verbiage in there that says that if you ever leave that organization, or if you ever decide to part with the one that you're presently with, then you cannot work in your profession for a specified period of time in that area. And there's normally a range listed. This is commonly seen in two forms. One is when you buy out a small business. For instance, let's say you're a plumber and you have a large plumbing business in an area, and somebody decides to buy out your business. They may include something like a non-compete clause saying that you cannot work as a plumber, you cannot create a plumbing company, or work in anything that deals with plumbing for a period of maybe 2-3 years for a 50-mile radius, a 100-mile radius, something like that. Another thing that might happen is, let's say that you're a doctor, because number two, in the medical field, this is very common, but it's in a lot of fields. So let's say that you're a doctor. It is common in the medical field for companies to say that if you ever leave that position, then you cannot operate as a doctor for a period of, say, a year within a 100-mile radius, unless it's outside of the state lines. So here in Northwest Florida, if a doctor's practice, let's say I don't know, gastro doctor, we'll say gastro doctors. So let's say that they're working for one medical practice that is controlled by a hospital, and a competing hospital decides to sweeten the pot a little bit and get that doctor to come over to their side. That doctor usually has to move out of state. Since we're so close to the Alabama line here in Northwest Florida, they'll just move across state to Alabama and work there for a year until that non-compete clause is gone, and then they'll go work for a competing hospital. This is very common. And so I think first we need to actually look and see what the federal government is proposing, and then go into this in more detail. All right, so what we have here is the press release that was posted January 5th, 2023 by the Federal Trade Commission. And so this is the Federal Trade Commission's website. So you're seeing it as I'm looking at it. The article that they posted in their press release is called "The FTC Proposes Rule to Ban Non-Compete Clauses Which Hurt Workers and Harm Competition. Agency estimates new rule could increase workers' earnings by nearly $300 billion per year." And as you see, it was done January 5th, 2023. These are tags that they have. So it's saying that they're proposing a new rule that would stop employers from doing non-compete clauses. And they explained that they feel it's an exploitative practice that suppresses wages, hampers innovation, and blocks entrepreneurs from starting new businesses. I'm interested in how they explain away the new businesses part. I think I know how they're doing it, but I'll talk about that later. They're saying that it could increase wages by nearly $300 billion per year and expand career opportunities for 300 million Americans. And then it's saying that they're seeking public comment on this proposed rule, that they're saying that preliminary findings say that they constitute a unfair method of competition, violate Section 5 of the Federal Trade Commission Act. So that's important to note, this Section 5 of the Federal Trade Commission Act. From here, it goes on ad nauseum about all the things that they think is so great and wonderful about this. And I would highly suggest that you read this article and go from there, as well as to read Section 5 of the Federal Trade Commission Act. Section 5 of the Federal Trade Commission Act is 15 U.S.C. 45, and it prohibits what they quote, "unfair or deceptive acts or practices in affecting commerce." So that is basically what Section 5 of this act does, is what they consider to be anything that might be unfair, deceptive, or a practice that might affect commerce. And so this is how the FTC claims that they have authority with this action. So it's 15 USC 45 is the law, section 5. 3, 2, 1. So you have basically been shown what the press release is, and you've been given a little bit more background into what the law is that's being referenced and also the sectional law. So this right now is so new that any comments will be nothing more than reactionary. The FTC has not provided any of their research to show where their $300 billion claim or 30 million Americans affected, where that actually comes from. Hopefully they'll release that, but they may or may not. We've seen this in the past with the federal government, that the government, they may release stuff and they may not. And if they do release it, it's on their own time, and there may be barriers to getting this information where only the biggest and strongest entities get it. So people like you and I may not be privy to such information. And so again, this is so new, we don't really know where we're at in even being able to get this information. This is quickly changing as we speak. I almost didn't learn about this. I saw a notice about it, and I thought it was clickbait. I thought it was this fake news clickbait mess, and then I read it, and I still didn't really believe what I was reading. So then I did my own research to find out that yes, it's true. Now, what does this mean for you? If you believe the federal government, which I don't believe the federal government for one moment, but let's say that we do, then they're saying that this will save, or this will impact the economy by $300 billion in the positive, and that 30 million Americans will be affected, actually over 30 million. I have a hard time with that figure. Now, on the pros, the government may be right. And there may be other benefits that they're not talking about, or that may not even be seen or investigated as of yet. For instance, we talked about one of the two ways, and I said one is due to a non-compete clause of a contract where you're buying out a company, and then the other is actually a traditional employment contract. And so in option 2, I talked about the doctor, and I used the gastro doctor as a example. Okay, so medicine, I mentioned earlier, is a field that is highly impacted by non-compete clauses. These hospitals, they spend a lot of money dealing with non-compete clauses, and a lot of money could be saved if we did not have non-compete clauses in medicine. So the ability of a doctor to move to and fro as they wish without having to move out of the area, that could be very beneficial to consumers. Although, to kind of counteract that contention, or to give a con to that contention, we have seen with big business, and we have seen with really the medical field itself, as reductions are seen, costs are not reduced to the consumer. So this is one of those things where it may actually save the healthcare industry billions of dollars. But we as consumers may not see that benefit as it relates to a reduction in our medical bills. So that is something to be wary of. Now, I'm not speaking as a mediator, and a lot of you know that I am. But I will state this. In the state of Florida, the practice of mediation is controlled by state statute. Not only does the government control and regulate the certification of mediators, but it also has a set of statutes that govern the practice of mediations. And in those statutes, it actually has a non-compete prohibition for mediation. So that means that I could sell my practice to another mediator and then open up a practice next day, and it would be illegal for that person buying my practice to put a contract in there with a non-compete provision. So what does that make my practice worth to another competitor wishing to buy me out? Zero. That's what a non-compete clause does. It can make the value of your business zero. If it's not zero, it is considerably less than what it would be with a non-compete clause. So that's important to understand. And this is where I come in with all these different pros and cons, because this is not a subject that really a nuclear option like the FTC is doing. That is probably not the right approach. A nuclear option normally is the best option only when it's the only option. I don't like nuclear options for anything. So how do I feel about this? Well, I really don't know yet. A lot of my colleagues that they're business consultants, and normally a lot of these are like higher level business consultants. I deal mostly in small business. So like if somebody hired me on to consult their small business and they said, I'm worried about a non-compete clause, one of the things that I may consult with them about is how to navigate and to negotiate a contract that really helps them out better with this non-compete issue. But these bigger ones, and I'll talk about that in a minute, but the bigger ones, they're more worried about how it will actually impact industries. Their clients are, multi-billion-dollar companies that are worried about this. And they're saying that it could actually cause maybe a $500 billion impact to the economy, meaning that the FTC's notion of a $300 billion savings, any benefits that they're claiming may be negated to a point we actually have a $200 billion loss because of this nuclear option. I don't know where their facts and figures are coming from either. So maybe it is, maybe it's not. We really don't know. And for them to come up with a figure this quick in response to the federal government's figures, which nobody knows where that comes from, it's more hearsay than it is fact. Here, let's look at what my role would be normally as a small business consultant. If a small business owner consulted with me and hired me as their consultant, and they said, I'm being bought out, or let's say that they're wanting to buy somebody else out, One of the issues that I would talk about is non-compete clauses. Now, a non-compete clause can hurt or help, and it's one of those that's not a if-then situation, or it's a all this, all that situation. It is sum sic, or as we say in Latin, or that's what we say in Latin, is sum sic. It means case by case. So the way it normally works is that I would be talking with them going, do you really want to work in this field anymore? Do you wish to actually work in this? Because if they do, a non-compete clause is going to hurt them. But they have to understand that the whole reason for the non-compete clause is to put enough value in their business that they can sell. If they're wanting to buy, and then I might talk to them about, do you really want to do a non-compete clause with this person to make it where they're now no longer working for you? Maybe they're an asset. This is a person that you can have on your payroll, telling you how things work, explaining everything until you can take over officially. So that's how this works normally. Nuts and bolts. And so there have been numerous people that I know of, or I've had the opportunity to hear them speak about their instances with non-compete clauses. Normally, if you're a small business owner, it is almost depressing when you sell your business and find out you no longer have a job, and moreover, you're banned from participating in that field for a specified period of time in a specified area, to where you'd have to pick up and move off your family. And so that's a huge thing. I've also known several businesses and had the opportunity to hear them where getting rid of a talent that actually built value into a company actually deteriorated the value of the business over time, because they did not factor in the value of the person. You got to think about it. The person that started the business usually matters as much or more than the assets. A lot of people right now are complaining about Elon Musk being the only person in history to ever lose nearly $200 billion. But you think about how vital that person is, that he could easily lose and gain back $200 billion like it's nothing. This person has a knack and a talent that is unsurpassed. So people like him exist everywhere. They're not common, but they exist in sufficient quantities that it happens in multiple fields. Maybe you install tile. You might be the best tile installer in your state, in your area. So a non-compete clause, that's not only going to hurt you, but it may actually hurt the company that buys if they can't keep you on to teach all your talents and to tell them all your tips and tricks that makes your product better than anybody else. On the other hand, think of me. All right, I'm a mediator. I don't normally talk about mediations that much, and I have to be very careful due to confidentiality. But I can state that in the state of Florida, there is a statute that prohibits non-compete clauses for mediators, which means that if a competing mediator wished to buy my practice from me, they could. And then the next day, I can start up my practice again under a new name, doing the same thing, and not even think twice about it. They couldn't do anything to me. Now, what does that make the value of my mediation practice? Zero. So there's going to be benefits There's going to be cons. We need to look at this. This is going to be a very dynamic issue. But I think one of the big issues is going to be, is this an overreach of government? And I think this is where the courts are going to weigh in heavily. Does the Federal Trade Commission, under Section 5 of the FTC Act, do they have sufficient authority to do this? I don't know. I have a feeling that they don't, but that'll be for a court to decide. And I have a saying that I tell my friends: illegal is a sick bird. Now, what does that mean? Well, if you spell out illegal, it's ill-eagle. It's a sick bird. It really depends on the judge, and even then, it depends on the executive branch to do something. Now, what I mean by that, in the past, the courts have been very capricious. If you think about early American history, the Hatfields and the McCoys, there is a great body of case law based upon that very real-life family feud that took place. And one of the case laws that stemmed from this feud was that one state violated the borders of another state to actually pursue, take, and bring back people that were charged for crimes. The states went to the Supreme Court and said that it was illegal to cross state lines by one state agency into another state's jurisdiction to apprehend somebody that had done no wrong in that state, that was being violated, that their rights were being violated, and to take them and bring them over and try them in another state. The Supreme Court, in very generic terms, please read the case law yourself, but in very generic terms, the Supreme Court said that even though it may be illegal, that if they successfully take a person after violating a state's boundaries and they bring them back to their state where they have jurisdiction, that it's okay. All right, so one of the tenets of the law is the courts are not supposed to recognize, condone, or benefit illegal activity. That's one of the cornerstones of the judicial process system. And yet the Supreme Court did that. And then you have other issues like with the executive branch. You know that I do have Cherokee heritage. There was a false treaty. It was not a legitimate treaty. And that is the reason why the Trail of Tears happened. It was not legal. And so the Cherokee Nation, which I am not a citizen of, they actually filed an action with the federal courts. And so the Supreme Court made a ruling saying that it was a legal treaty and that the federal government had no right to remove. Well, Andrew Jackson, the first Democratic president of the United States, he made a saying basically that he basically said that the Supreme Court made a rule or made a law. Now they had to enforce it, knowing that enforcement of laws is the executive branch. And so that is how the Native Americans were moved mostly to Oklahoma, or what would become Oklahoma. I think this is what we have here. We have a president that seems to do as he wishes, and he understands the authority and power of the executive branch. We have a court system that is badly broken, and they may or may not side with a given side. If it ever makes it to the Supreme Court, more than likely they'll rule that this is illegal. But if it never makes it to the Supreme Court, then there's different districts that will vote one way or the other, with the ninth probably voting in favor of the FTC because they're the most liberal out of these. So we could have a long, protracted battle if this ever becomes enacted, with some areas of the U.S. being protected and some areas not. So I think this is worth keeping an eye on. It is going to be changing. There's going to be different facets to it that evolve over time. But I'm interested to see what your opinion is on this. If you have any questions, put it down below. If you have any thoughts on this matter, please put it down below. And as I learn more information, I may do another video in the future. If you'd like to be updated, please let me know. And with that, if you like this video, please give us a like. That really does help. Your comments help. If you're not subscribed, and if you listened up to now, why aren't you subscribing? Go ahead, hit that subscription button. It's free. You don't have to pay anything. And then hit that notification bell so you can be alerted to future videos. And with that, I'll see you again next time. Bye.